Hi everyone, welcome to the launch of episode 57, Changes to the Family Law Legislation. I am Benjamin Bryant from Bryant McKinnon Lawyers, and I'm joined here with Heather from Bryant McKinnon Lawyers.
How are you, Benjamin?
I'm well, thank you. Like I said, episode 57, Changes to Family Law Legislation. Now, 6th of May, Heather, 2024 was a pretty significant time for us. Big overhaul of the Family Law Act, and those new changes came in specifically in respect to parenting issues, okay? And this is a really unique time for us and a unique, episode to be giving our listeners and our viewers. And that's because we kind of come from a different view. We get to the same place, like we are all both about best interests of children and have always been and always will be. But in terms of how we approach to get there and what the Family Law Act amendments actually mean, it's a different view, yeah?
Yeah. You love the formality of the framework, and I understand that that's what your generation were brought up with, because by the time you went to law school, we had a framework for deciding children's matters. But in the episode, we talk about the philosophical differences in using legislation as the framework and using, I suppose, if you like, best interest of children as the only test. And we talk about the different views, and it's what makes us great in partnership, because our team of lawyers get a background from both of us.
Yeah, of course.
Yeah.
And just you mentioned the word framework, and I thought I'd just give a little spiel to our listeners this afternoon, although I will be quick. I could speak for a while, but I will be quick. Essentially, the two major things are this. There was a presumption that parents would have equal shared parental responsibility for children. That is, that they will have equal decision-making powers for the major long-term stuff for kids. That's completely gone. There's no more that presumption. It's on a case-by-case basis. The second thing, Heather, in the framework was these two pillars, these ideas that we're balancing risk and relationship, meaningful relationship with both parents, and keeping children safe. What Section 60cc now says is we keep children safe, and if it's safe to do so, we factor into all these other things. And about number 4 is relationship with parents, carers, grandparents, and things like that. So we'll see. We'll see if it is just business as usual. We're using the same framework, but we're not referring to it anymore, or whether this is a brave new world.
Yeah, I think the focus on children's safety is something that has really come to the fore with the concentration on the stats about, the violent institution of a family and how many people are killed within the four walls of their own home.
Yeah.
But I think one of the other things that's really important about the changes is that concentration on that particular child's interests. So we talk about the fact you might have 3 or 4 children in the same family, and they may have completely different needs. For example, one may be autistic and the siblings aren't. So we really look at how the court's going to tailor-make arrangements now for each little one, not some blanket order that just covers everything.
Absolutely. And look, what we do agree on, Heather, is that this episode is absolutely essential to anyone that's going to court on children's matters. You can check out episode 57 of the Family Matters podcast, Changes to the Family Law Legislation, wherever you get your podcasts, or at our website, bryantmckinnon.com.